Okay, sometimes we have topics on the show that are a little bit complicated.
Yeah.
And I like to start the show by saying, okay, you got to pretend like you're in law school today. Today is one of those days, okay? Why? Because we have a very, very important case that came out of the Florida 3rd District Court of Appeal within the last 2 weeks. And believe me, it's a topic that we really need to talk about. The 3rd District Court of Appeal handles appeals from Dade and Monroe counties, right? So as we do in law school, like it would be like, okay, Mr. Glazer, tell us the facts, right? So
the mens rea.
Here's the facts. Okay.
Okay.
You ready?
Ready.
So we have a unit owner, Angelica Avila, and several owners at the Biscayne 21 condo. They didn't take the money. And I think, Rob, you're putting up a picture of that condo as we speak, right? They didn't take the money. Instead, the owners, they voted against selling their condominium units to a developer by the name of TRD Biscayne. And that developer was attempting to buy enough units to terminate the condo. Why? Because they would want to knock it down and redevelop and resell the property.
Right.
Listen, not only have we talked about it, it's going to be a hot topic in the future.
Right.
Okay, but these specific owners said, we're not selling. Okay? Now, what's important to know? The declaration of condominium required the unanimous assent of all the owners in order to terminate the condominium.
Did the developer know that?
Probably should have known it.
Yes.
Right? Should have known.
Right, because the game over.
Absolutely. You would think game over, right?
Right.
But the association acting on behalf of the developer and now the owner of most of the units at the time, they didn't take no for an answer. So what did the association do? Instead, the association amended the declaration of condominium to change the unanimity requirement.
Because they don't need a unanimous to change the deck.
To change the deck, right. So they changed it now to say, okay, we'll go back to what the current law says. The current law says we can terminate with 80%. So even though the deck said you need 100, we could amend with 80%. We'll amend with 80%, and we'll knock the number down from unanimous to 80%.
Sounds kosher to me.
Is it kosher? So the unit owners filed suit, and they sought an injunction to block this change and the resulting termination.
Did those unit owners vote?
They voted against it. Yeah,
but they didn't make the threshold.
Didn't make the threshold, right. There was more than 80% of the people voted for it, right? They argued that the original declaration contained provisions requiring unanimity to terminate the condo or to amend any provision that impacts their voting rights. So important to note in this case is there was no as amended from time to time language either. So they don't automatically get to the 80% that would be in the statute today.
So the Kaufman language also governs over your docs.
Absolutely. So
what happens internally, not only the state laws, but also what changing the docs as they are today.
If there was Kaufman language, if there was, right? Okay. So then automatically the new laws that would have said, okay, you can terminate now with 80%, that would apply. That would apply, even though there was a unanimity.
But I'm just saying,
that wasn't in there either.
Oh, but it was within the condo this time that the Kaufman would also apply. So that's interesting.
Correct. It would have. That's right. Okay. So, could the owners get around this 100% requirement by amending the declaration, which only required 80% to amend? That was the real question. So, the court first noted that the declaration had a clause which stated that an amendment altering the voting rights of any owners of the condo shall require the approval of 100% of the owners. Anything that alters the voting rights, okay? Now, the 3rd DCA first opined that decreasing the percentage required for termination was an amendment that impacts the voting rights of the owners, right? And therefore, unanimity was required. So that's step one. Okay, and just like is happening all over the state over time, the developer accumulated more and more units, and then when it owned enough units to amend the declaration, they voted to amend the declaration to reduce the unanimity requirement to only 80% as allowed under the current termination provision of the Condo Act. And we're going to start seeing these attempts more and more and more.
So it amended 2 provisions.
The declaration was amended to knock the requirement down to 80% in order to, and they did it because the deck originally only required 80% to amend. So forget the 100% unanimity. We only needed 80% to amend, so we're amending.
But what about the 100% to change the way you vote? Can they change that?
The court said no. You couldn't do that either.
And they can't change that?
You can't do that with 80%. Okay. The court said you couldn't do that.
But can they change that rule?
No. The court, as we'll see, the court said no, absolutely not.
All right.
So the unit owners argued that the amendment to the declaration voided their right to, in effect, veto a termination, and therefore it materially altered their voting rights, right? They had this powerful veto right to veto a termination. Well, the owners argued that that certainly materially altered our rights to a veto. Can't do that.
I have a question. Are these 2 unit owners that are doing this, are they paying all their legal bills by themselves?
Yes, they sure are. I know them. They sure were.
So it's not the association paying.
They're
and
fighting
the developer that has big pockets, deep pockets,
they're fighting it on their own. Absolutely
that is
fighting it on their own.
Amazing.
Yep. The developer claimed this was we're not doing anything to their voting rights. We're not affecting their voting rights. That's nonsense because the owners still had a right to vote. Therefore, their voting rights were not materially altered. Ridiculous argument.
Yeah.
Right? Of course, the rights were being altered. So the court held that by requiring a unanimous vote for termination, the declaration originally gave the owners this powerful veto right over any termination plan, and that would be lost if this amendment, right, were allowed to stand that knocked it down to 80%. So what happened? Case goes to the 3rd DCA, and the 3rd DCA rules in favor of
the developer.
The unit owners.
Oh my gosh.
Developers lost.
I can't believe that.
So the 3rd DCA says nope.
What about the Supreme Court, though?
100% means 100%. Okay, so let's talk about the Supreme Court. So the Supreme Court actually works itself into this opinion.
Sure.
Okay, and we'll figure out why.
Okay.
So let's back up for a second. So why is this so important? Because we know it's certainly no secret that developers out there, we know they're smelling blood in the water, right?
So I just want to ask you, is Biscayne 21 condominium, did they have a large nut to pay in terms of their Sears and
absolutely,
and that's why everyone's getting out because they can't afford it?
Correct. So developers, like I was saying, the developers smell blood in the water.
So these 2 people can afford these reserves, apparently.
They probably can. Okay, they probably can, and maybe they don't want to sell, and maybe they love where they currently live, and maybe they bought there because they love the view and they love the building, they love their unit, and they don't want to sell. But what do developers know? Developers know that unit owners in condos, especially ones that are 30 years old, or especially ones that are on the water, what does everybody in the building have to pay for now? A phase 1 study by an architect or engineer, a phase 2 study probably, mandatory repairs for the milestone inspections in order to pass them, mandatory reserves, mandatory contribution of reserves for the structural integrity reserve study to do the reserve study, massive insurance payments.
Oh, yeah.
And what about those condos still that haven't put in their sprinklers or their life safety, okay?
So the developer,
think of what we're talking about.
The developer buys all these units, and then these 2 hold out, and the developer can't knock it down and build a new one, so they're stuck.
That's correct. And are they stuck?
And they're going to have to pay to fix the building now.
Correct.
Which doesn't help them at all.
So the question is, can one person, if the vote requires unanimity, right, let's say you got 300 units in the condo. Think about this. 299 say, we can't afford this. Thank God there's a developer out there who wants to buy us out.
Right.
One person says, nope, I'm not selling.
So are all the other sales contingent on the Avias?
Yes, it is.
Oh.
Yeah, so they can't knock it down. Right?
But they haven't actually paid and bought those units,
That's correct. Normally, it's contingent upon everybody or nobody.
But
So-
how are they able to vote if they haven't actually bought the units from everybody?
No. I'm saying the
Oh.
developer will put a contract out there that says, I'm willing to buy everybody's unit, but it's got to be everybody or nobody. Now, if they
Oh.
can't get everybody, that means, my God, everybody in the building is stuck because one person won't sell out. One person can hold up everything. Think about that.
So the unit owners that the developers were buying their units were the ones that voted for it.
They wanted to sell out, right.
Okay.
But you had those few
Got it.
that said, nope, I'll never sell.
Okay.
So now the developer has to walk away. Now think about that.
Yeah.
So everybody else, even though they might not be able to afford it, they're stuck paying all these costs. Now, is that
Well,
fair?
they could sell individually to people, but no one's
Who's
going to
gonna
come
buy?
in and buy
Right.
it.
Who's
right.
gonna buy?
Oh, my
Right?
God.
So should it be fair? Some people argue, the documents are not fair. Should one or two or three people in
Who
a
can
whole
afford
building who can afford it be able to hold up the sale for everybody else? So you mentioned the Florida Supreme Court. This gets complicated. So every once in a while, the lower courts, the appellate courts, will say, okay, there's an issue of such significance that the Court of Appeals themselves is going to kick it up to the Supreme Court themselves, even without the parties moving for it. The third DCA themselves. So
there's like this needs to go further.
Exactly. So, and it's called sometimes certifying a question of great public importance to the Supreme Court. You ready?
Yeah.
So the third DCA certified the following questions of public importance to the Supreme Court. 1, may an amendment altering the voting threshold required to terminate a condominium pass without unanimous approval, where a condominium declaration both, 1, requires unanimous approval of the owners before either terminating the condo or passing any amendment to the declaration of condo, altering a unit owner's voting rights, and 2, where it lacks Kaufman language automatically incorporating relevant statutory changes into the contractual provisions. Remember, if there was Kaufman language here, the new statutes would automatically implied it would have been
was no
allowed by 80%.
Right.
Okay?
Right. But the
So
Kaufman.
Kaufman language wasn't there.
How long is it going to take for the Florida Supreme Court to answer these two questions?
Okay, now I'm guessing this is going to be answered within about 9 months to a year.
For God's sakes.
That's how it's going to take how long it's going to take for the Florida Supreme Court to answer these questions. But make no mistake, the answer to these questions, because right now we even have a split between the 3rd and 4th District Courts of Appeal, this is going to have massive ramifications on hundreds, if not thousands, of condominiums throughout the state.
Right. I wonder if they're going to solve this Kaufman language situation.
It's a question that's out there.
Because it needs to be done.
No
one
question.
needs to do anything if you've got Kaufman, right?
That's correct. In this situation, they wouldn't have to do anything. They would have been able to use the 80%. Kaufman language wasn't there. Stuck with unanimity. Okay?
But I mean, in terms of the Sears and all of that, and
That's a different story.
I know, but I'm wondering if they're going to address that with this.
Maybe, maybe not. I mean, the Kaufman situation,
Pretty big deal.
It's a very big deal. It creates a lot of confusion among even legislators. We have a legislator holding on the phone, right? I bet you the legislator who's calling in, nobody even realizes that when they pass a law, it may not apply in the condos that they think it's applying to.
Because the number 2 question is lacks Kaufman language automatically, and you can plug in anything. So if they rule that it doesn't matter, then maybe that would be precedent for it all.
Right. Do I think they're going to do that? No.
Oh.
I don't think they're going to do that.
Because it's a contract. Because they ruled against you.
Contract. There you go. You didn't have to.
Because you lost to
I lost, but it was close, 7-0. So anyway, this is going to determine whether a single owner can prevent condo termination where everybody else wants out desperately.
Didn't you ever see the movie Up?
Importance of this.
The guy with the balloons in the house and he wouldn't sell his land?
No.
Oh, yeah, that happens all the time. People don't sell.
Serious, and you're talking to me about Up, you know what I'm saying? but yeah.
It happens. People don't want to sell their land.
Wait for this decision.
This is
going to be a monster. Yeah. Every once in a while we get a major decision on condo law. This is going to be that decision. Okay? Complicated topic. Anybody have any questions on this or anything else? We're waiting for your call.